right before they present. But immediately we will introduce Clifton George Reader, who is going to speak to resilience in the tourism sector. Clifton was promoted to Managing Director of Moon Palace, Jamaica in November 2016, which is Palace Resort's first property outside of Mexico. In his role as Managing Director, Mr. Reed oversees the overall operation of the resort, including staff development, budgeting, and guest satisfaction. He's also tasked with overseeing the new projects of the resort. And he is president of the Jamaica Hotel and Tourist Association, the JHTA, which responsibility, by the way, he has taken on during one of the most challenging times the industry has ever faced. Mr. Reeder's impressive hospitality career spans over 3 decades among various local and international hotels. Prior to his post as Director of Moon Palace, Jamaica, he served as General Manager of Sunset Jamaica Grand Resort and Spa, as General Manager of Beaches The Grill Resort and Spa, and Beaches Sandy Bay. He brings a deep-rooted understanding of the local market and region, valuable experience, and great enthusiasm to his post at Moon Palace, Jamaica. By the way, he also serves as counselor for the Ocho Rios Runaway Bay chapter of the Jamaica Hotel and Tourist Association. He also serves as president of the Moon Palace Foundation, the social welfare arm of Moon Palace, Jamaica Grand. Welcome, Clifton.
Good morning. Thank you very much, Chairman. Okay, this morning I'll be speaking about the resilience of the tourism sector. I would not say that the tourism sector is just resilient. It was purpose-built because as early as January 2020, we set about putting in an infrastructure that saw us through to where we are now. We developed then the Resilient Corridor. The Resilient Corridor was designed to insulate tourists coming into the island from our local population, because at the time, it was thought that the tourists would basically bring the virus to Jamaica. TPDCO was tasked with ensuring the protocols developed then for the corridor, that they were met. The corridor basically runs from Negril in the west through to St. Elizabeth and right through to Port Antonio. Kingston is actually in its own little bubble and not necessarily part of the corridor. So when guests would arrive to Jamaica, they would go through the airport and be quarantined, so to speak, within the corridor. We were certified by TPDCO. We were given all our protocols. Some people developed additional protocols. But what we found out was the fact that halfway into opening, because the industry opened up June 15, 2020, after closing down, after one of our best years, 2019. I remember us moving from 90% occupancies in some hotels to 0 in 10 days. So when we reopened, we were taking back employees, retraining, resensitizing employees. But one of the things that the protocols did not speak to is the fact that employees were in a bubble once they would be at work, but leaving to go home, they would be outside the bubble. So that's when we formed the ambassador program. And this ambassador program took trained employees and sent them into the communities with TEF donated masks. Over 20,000 masks were donated by by TEF, sorry, and other donations. So we distributed over 30,000 masks to communities, to institutions, even to the police, for them to wear whilst they're enforcing in the communities. Going through, we started at very, very low occupancies, 9%, 10%. Then we went into September. We were looking forward to a very good winter, but that was not to be because we started to get spiked after the holiday period, and we had to go into more stringent measures in terms of putting in tighter curfews amongst other measures that the government enacted at the time. But tourism persisted through all of that into December, when we did fairly well. But one of the things that I believe helped us a lot is the fact that we were able to react to the Americans, because remember that Britain closed their borders, Canada closed their borders, so the only arrivals into Jamaica came out of the US. We never stopped the marketing in the US. We always, the tourist board did a fantastic job marketing through the United States. But all tourists were expected to do a negative antigen test going back to the US, because Jamaica before had it where tourists coming in had to do present a negative antigen test coming in. But the United States then said, look here, we want negative antigen tests going back. So tourism got together, and in 7 days, we were able to get the labs together, MOH, and put together a certification program for labs so that we could get all our visitors tested, ready to go back. Because if we had failed at that exercise, then tourism would have failed. But we were successful, and to date, most of the larger hotels are testing in excess, I would say, of 200 people per day going back. The prices were prohibitive at the time, and they still are high. We started out anywhere from $200 on PCR tests, that's what the Canadians required to go back, and up to $100 for the antigen test, which is now, through the efforts of lobbying groups and everything from JHTA and others, we brought them down to $22 or less. And you can now get a PCR test within the hotels for $100, because this, of course, represented additional cost to the hotels. So some hotels took the format that they would pay at least for 2 guests per room, and then the guests pay the difference. But we realized quickly that Mexico, Domrep, they weren't charging anything, and they didn't have any requirements literally for guests to go to those countries. So they started to compete in a big way with us. But we decided that we were gonna stick with our protocols. We were gonna ensure that the protocols protect our team members, protect our guests, and by extension, protect our communities. I am pleased to say that after January, we saw that our occupancy started to go up. People started to have more and more confidence in the hotel sector. And we were running into the 30s, into the 40%, which I can tell you, most hotels break even somewhere about 65 to 70% occupancy. So we were still losing money, but cost containing as we went along. So it has been 15 months of real cost containment, working with the protocols, spending. Some hotels invested up to 150,000 US dollars, putting in the protocols, and maybe another 20 or $30,000 per month, just buying different gears and putting in different infrastructure, making sure that they have sanitizers, they have everything ready for the guests, ready for staff as the guests come into our properties. Throughout the time period, we've had inspections from TPDCO, from Minister Mackenzie's office, and MOH, of course. We've done very well because through JHTA, we've basically said to everybody, make sure you maintain the protocols, because we could see another shutdown. And I am very proud that except for one or two infractions, the tourism industry has done exceptionally well maintaining those protocols. We have proven beyond a shadow of a doubt that the protocols work. The ambassador program was built on 4 pillars: wear your mask, physical distancing, wash your hands, and sanitizing. And those protocols today, if you follow them, you can avoid getting the virus. We've seen over the testing period from January 26 last year, when the US imposed the fact that we had to test everybody going back into the US. We've kept records through the labs, through the hotels, because we have testing sites in the hotels. And the positivity rate amongst tourists going back to the US has been less than 1%. It has gone down, it went down several times to 0.37%. So with that in mind, and the fact that we've seen very little in terms of positivity amongst the staff, shows that the protocols have worked and will continue to work. Another thing that we're looking at right now is the fact that where we are now, that we can stand at averaging 55% in the industry, we are looking to maintain this kind of occupancy going forward, to maintain our employees, because remember, we had 175,000 people in tourism, and I would say at least 130,000 were out of work, because we were able to retain some of them during the closure, but gradually, I think now we've brought back between 50 and 60% of tourism workers. In fact, in the hotels, it's probably up to 90 or 95%, but regrettably so, cruise ship has not started, and the transportation sector, the craft sector, and the attractions have not been able to bring back all their people. So that's affecting employment in that area. The government also assisted us during this period because they put in best cash for institutions and set cash for those employees who were not at work during the period. I know there were several salary cuts and several people stayed, work from home, all of the things that we could have employed through technology to make sure that tourism survived and will flourish in the future. We know that we have the Delta variants coming up, or maybe it's here, we don't know yet. We're waiting for MOH to let us know. But whatever it is, we believe that if we follow the protocols and be vaccinated, the industry will be resilient and continue so way into the future. This virus, I don't think it's gonna go away next week, next month, or even next year. But we have to learn to live with it. And as the Prime Minister said, we have to balance lives with livelihood. We have to expand our medical infrastructure, because that's another way. If our residents are sick, they will need to go to hospitals. If our guests are sick, they will need to utilize our hospitals. But we want to make sure that the product continue to survive. And from our experience in the last 15 months, I believe we will be well on our way to be successful and to ensure that we chart a way forward in our resilient corridor. Thank you very much.
Thank you, Clifton. You have heard from the president of the Jamaica Hotel and Tourist Association about the resilience in the sector. There's another perspective that we want to look at now, which is subject of which is the vaccination policies for tourism sector. I think there's a lot of interest here because there's going to be some discussion about the legal status of mandatory vaccination policies going to be presented by Emil Libo. Emil is a partner of DunnCox and head of the firm's litigation department, and was president of the Jamaica Bar Association from 2019 to present. He practices in employment law and civil litigation, specializing primarily in commercial litigation. He has acted for international and local clients in providing general labor law advice, drafting, and reviewing policy manuals and contracts of employment, advising on claims for bargaining rights by unions, and acted in contested dismissal claims in the Industrial Disputes Tribunal, Supreme Court, and Court of Appeal. He has also acted for maritime clients and litigated contested ship arrest applications at the Supreme Court and appellate levels, in addition to other substantive maritime claims. Emil has presented at seminars and published articles on labor and maritime law. He has also established a reputation for successfully litigating contested property disputes involving rights claimed under restrictive covenants, mortgages, and debentures, including securing the first demolition order on behalf of a private citizen in contested litigation in Jamaica. So he has more than half a dozen publications and presentations under his belt. Emil practiced in property and commercial law prior to specializing in litigation and employment law. He's a member of the Board of Management of Tax Administration Jamaica. He's a member of the Council, Executive and Social Affairs Committee of the Jamaica Bar Association, the Jamaica Chamber of Commerce, Legislation and Regulation Subcommittee, the Betting, Gaming and Lotteries Commission, First Instance Tribunal, and chairperson of Jambar Employment and Labor Law Subcommittee. He has also served as honorary counsel to the Little Theatre Movement of Jamaica and is an associate tutor in civil procedure and practice at Norman Manley Law School. So he has fairly extensive experience as lead counsel. Emil is also in his substantive work, former commissioner of the Fair Trading Commission, a member and former president of Jamdamas Running Club, a primary organizer of the internationally known Reggae Marathon, over in the grill in December. And an avid marathon runner himself and triathlete who has participated in several international events. I don't know how he finds time to do all of that with his extensive resume, but this is Emil. Welcome, Emil.
Thanks very much, Chris. I should just add two additional points. Thanks very much for that introduction. I'm now the immediate past president of the Jamaican Bar Association. I demitted office earlier this month. Yes, so I'm into retirement in terms of that aspect of things. But I should also add that Chris Jarrett is one of the best non-professional marathon runners I think we have in Jamaica. Your best marathon time, Chris, was it 3 hours 20, or did you go sub 3?
Did sub 3,
Sub 3.
254.
My apologies.
That's all right.
Yes, under 3 hours for 26.2 miles. So that is certainly worthy of accolade. Any roader would know that 26.2 miles in under 3 hours is an accomplishment. When I try to give people who don't run a feel of what 26 miles is, I tell them from Content Spring Tax Office to Hellshire Beach is 18 miles. So on foot is, and we have had those runs. If you run from Content Spring to Hellshire Beach, that's 18 miles. So if you're doing a marathon, you'd have 8 more miles to go after that. But yes, thanks much, Chris. We'll get to the topic at hand that people are here to see.
Yes.
Yes. So good morning, everyone. Thank you very much for coming. As we share with you this morning about the interplay between vaccination and the law. These are one of the areas where the law and science and medicine intersect. As we know, the vaccination conversation is constantly changing, it's constantly in flux. As it is now in Jamaica, the government, as I understand it, has opened up vaccination to everyone who is 18 years and older. So we knew that previously in Jamaica, outside of the Blitz events, vaccination was limited to particular age categories. So does the fact that, at least for now, until the current supply runs out, that vaccines are available to everyone in Jamaica, 18 years and older, does that now impact on what employers can insist on, and what is the government's role in all of this? So I hope by the end of the presentation, you will have a better feel for some of these issues. But I'll first tell you, as they say, spoiler alert, there is no definitive conclusion that you can arrive at now, because as I said, it's in a constant state of flux. So this is really intended to be a snapshot as to how things are now. Right. So without further ado, vaccine. In the context of the tourism industry, it brings many categories of people together. So you have short-term contract workers. So those are your workers who will come on your 3-month contract for your high season, and then they would go on a contract break, and then you may bring them back on another occasion. That tends to be a line staff. You have your permanent employees, who tend to be your higher management level employees, who help to run your organization in terms of being in charge of rooms, facilities, kitchen, and things like that you will always need. You have your independent contractors who come in and out of the property, perhaps will come and fix something depending on the size of the property. You may not have a dedicated maintenance staff. So you will also have your delivery personnel and so on. And of course, the most necessary element for any category in the tourism sector is visitors or guests, right? Now, you have different contractual relationships with each of these categories, right? And so we're going to explore a bit the differing relationships that you have with these categories of individuals and how this interplays with the whole concept of vaccination and COVID protocols and requirements. Now, in Jamaica, we are more used to the term immunization than we are to the term vaccination. So immunization has existed in Jamaica, certainly under the Public Health Act. So the Public Health Act is the only laws I've been able to pick up in Jamaica that governs vaccination. So under Section 14 of the Public Health Act, the Minister of Health has the power to make regulations regarding vaccinations. The only regulation issued under this section regarding vaccinations or immunizations, as we refer to it in the legislation, are the Public Health Immunization Regulations 1986. So as we debate this whole question about mandatory vaccination or no mandatory vaccination, mandatory vaccination has existed in Jamaica since 1986. So it is not a new concept that is known, that will be introduced into Jamaican law. So under the existing regulations, they specify that all parents must vaccinate their children, and all children under the age of 7 years must be adequately immunized before school entry. So non-compliance with the regulation results in a fee, right? Fine, sorry, not a fee. And also the child would be prohibited from either entering the school or remaining in the school if the child is not vaccinated. So you can see there that there is already in place a structure in Jamaica whereby parents are obliged or mandated to vaccinate or immunize their children. So as a consequence, you'll see that many, and in most instances, when a child is born in Jamaica in a hospital, the public health nurse will come and will administer that child's immunization. Most Jamaicans of a certain generation have their vaccine passport on their arms. It's a specific marking reflecting that you receive those initial shots. So that is the law that introduced mandatory vaccination in Jamaica. Of course, there's currently no law in place requiring adult vaccination. However, in preparing for this paper, I noted that on the Ministry of Health website, there appears to be an intention on the part of the ministry to institute a national vaccination policy and plan to address the administration of COVID-19 vaccines in Jamaica. So they have yet to put in place and implement any type of mandatory adult vaccination system. Although we have heard various comments being made by the Minister of Health and by the Prime Minister regarding the steps that might possibly be taken in regard to vaccinations. But we also see where there might be different treatment in terms of mandating, and depending on the category or the sector in which you fall. because it should also be noted that the government, the GOJ, is both, they have two roles. They're both, on one breath, the largest employer of labor in Jamaica, the single largest employer of labor in Jamaica, as well as having the ability to issue legislation. So until a policy is implemented and made law, what is it that we should do? Is it the wild, wild west of vaccinations for employers and tourism operators? So the answer is yes and no. So as I've just indicated, there is no specific law which guides COVID and vaccinations against COVID in Jamaica. So how do we address that? We address that with contracts. So contracts can take many forms. And I'm sure everyone here knows fundamentally that a contract is simply an agreement between two parties that's usually in written form, but can be oral as well as written, or even by conduct, just by the way in which you have operated. Somebody has provided a service to you for many years, you have paid them for that service. In the typical situation we'd be most familiar with is a domestic worker. A domestic worker and gardener, you don't have a written contract, or most people don't have a written contract with your domestic worker. But they come, they provide a service that, the parameters are roughly set and you pay them for it. Now, hopefully, everyone in the tourism sector who employs labor does not have that type of contract with their employees, but in fact has a written contract which clearly sets out the terms of employment. And in addition to that employment contract, you also need to have policies in place. So there are entities that I work with that since COVID have implemented COVID-19 policies. And if you read some of the literature, you may well wish to call that pandemic policies, because after COVID-19, there may be COVID-22, although we really hope not. So one of the ways in which you can address protocols and so on, which is not appropriate to be placed in an employment contract, is to set it out in a policy. So those two documents usually would cover your employment relationships, right? Registration forms and indemnity forms. I'm sure most are familiar that guests, when they enter the hotel, they would sign a registration form, and that tells them what they can and cannot do on the property. Perhaps it exempts the hotel from certain liability and so on. And that usually is the form of contract between the hotel and the guest. An indemnity form is basically a form by which the person signing the form has said, I am agreeing that I will not hold you liable in respect of the particular issue or area that I may be exposed to risk. So, as I said, the type of contract that you engage or initiate depends on who you're speaking to, right? Now, it is very important that these documents be signed by the other party to the contract. So it doesn't make sense when you have an employee who is not following your policy, not following your protocol, not following their contract. When you pull the file, and hopefully they have one, the contract is not signed. So you're always going to have a challenge enforcing any document where the employee has not documented their agreement to it. And of course, for independent contractors, you'd be best served by having a form that's attached to work instructions, setting out the terms on which they're entering the property, protocols they must follow while doing so, and what will happen if they fail to comply. So having the right contract really is about anticipation, anticipating what could go wrong, and if it is that they don't comply, what do you do? So many businesses or entities, when they engage independent contractors, is really just as on an invoice, and the invoice is what forms the terms on which that independent contractor provides a service. However, in the current environment, if it is that you wish to enforce any type of protocol and so on, you need to attach that to work instructions. For guests, no. A lot of the issues would relate to the timing of when you enter into that contract with the guests, right? Now, usually the registration form is signed and the guest has arrived. I am suggesting that that is actually too late, because when that guest has flown from their country of residence to Jamaica and now refuses to sign off on your policy registration form, what do? It places the hotel in a very invidious position, in that you are not likely to want to put the guest in a situation where they have nowhere to stay in Jamaica. They've already booked the hotel, and they are now in a position where they are not able to take advantage of that, and you're telling them that they need to go find somewhere else. Now, as the occupier premises, you're also free. But let's say you're the occupier, meaning that you either own or lease the property. So you have control over who comes in, who goes out. And so that is one of your rights, your right to your property under the law, and to choose who you wish to let onto your property and who you don't. Now, as an occupier of the premises, you can also limit who can come on it and the conditions that they should fulfill, right? So this will include a right to request proof of vaccination, right? So if it is that you wish to implement a requirement for visitors to your properties, and this would include, for the purposes of occupiers' liability, guests, employees, and independent contractors, you would have a right to request proof of vaccination as a precondition. Now, one of the issues that has arisen in the vaccination debate and discussion is whether, as an employer, you can force an employee to disclose their vaccination status. Because unless the vaccination is taking place on your property, you yourself will have no certainty as to whether an employee is vaccinated or not. So the general principle is that you can't force an existing employee to disclose medical information unless their potential medical condition is one that may serve to endanger other employees or somehow present a danger based on the type of job they're engaged in. So let's say you have a communicable disease that is transmitted by blood. They may well be a reasonable basis to exclude you from a job in the kitchen, right? And so if it is that you do have a condition that is communicable and can pose a danger to other employees, then that is something I would argue that you can require some level of disclosure. Now, for new hires, of course, the situation is a little different because as a prospective employer, you can now set the terms and conditions under which you will employ a member of staff. And so what we're saying here is that, and it is not unknown, for example, for some employers to require you to do a medical examination to ensure that you're fit to work as a condition for your employment to commence. So there is, as I had said in the beginning, no clear path necessarily regarding the vaccination discussion, because your ability to seek to mandate it will really depend upon the science, and that's equally true in relation to the law. What we're seeing now with vaccination is that vaccination is not the panacea that we all hoped it would be, but I think it is generally held to be correct that it is better for you to be vaccinated than not. So when it is that you're looking at vaccination issues and questions, as I said, your first question is in what category does this other person fall under in terms of how you treat them from a contractual standpoint. And then once you have determined the category, you have to then look at what is the right form of contract and wording of a contract that you would need to have in place in order to ensure that your policies for your property, for your operations are properly implemented and enforced. Thank you very much. I'll now hand you over to Mr. Morgan.
Yes, thank you, Emil. That was comprehensive outlook. We always happy to get the free legal advice. So we have taken notes, I'm sure, speaking for myself with respect to registration procedures and proof of vaccination requirements as a precondition now to employment and so on, contracts and such. So thank you so much for that presentation, Emil Libo. We have up next presentation by another partner of DunnCox, Jonathan Morgan. Mr. Morgan was called to the Jamaican Bar and Trinidad and Tobago Bar in 2014, and is a member of the firm's Litigation and Alternative Dispute Resolution Department. His years in practice have been spent in leading and supporting roles in complex civil and commercial litigation matters. Mr. Morgan's commercial litigation experience includes acting on behalf of financial institutions, insurance companies, construction and mining companies, and other major players in corporate Jamaica. This practice covers a broad array of litigation matters, including property claims, debt collection, labor disputes, and contractual disputes. He has also played a pivotal role in advising corporate entities on labor issues and areas of regulatory compliance. He also has extensive experience as lead counsel, as does Emil. And in his formative years, he demonstrated early signs of prowess for legal research and advocacy by participating in the 2007 Model United Nations Assembly in Trinidad, the 2009 Youth Forum of the 5th Summit of the Americas, Trinidad, the 2012 World Universities Debating Championship in Turkey, the 2013 and 2014 Philip Jessup International Moot Court competitions in Washington, D.C. in the United States. there seems to be quite an extensive amount of legal knowledge there at DunnCox. And Jonathan is also a former president of the youth of the United Nations group Trinidad and Tobago, and has served as a volunteer of both Circle K International, Barbados, and youth branch of Rotary International, Trinidad and Tobago. Please join me in welcoming Jonathan. Over to you, Jonathan. Jonathan is going to be speaking on the understanding of how to treat with work from home directives. The subject matter will include restructuring of your workforce without exposure to employment claims.
Chris, thank you so much, and good morning to everyone. It's my pleasure to address the focus of restructuring your workforce, particularly in the tourism industry. And if we may just dive right in. So the tourism industry is uniquely placed. We have hotels, resorts, adventure parks, tour guides, craft markets, or restaurateurs, all major parts of what the tourism industry is. And for many of us, for many of our companies, it's very easy to consider them independent businesses that have their respective balance sheets, their financial requirements, and a lot of numbers that are worth crunching. But at the heart of what the members of the tourism industry represent is that they are in fact service providers. As service providers, our focus should not be solely on the numbers, not solely on what is necessary to make a profit, but it should be on what is necessary to provide a service. And on that basis, our human resource, I think, is our greatest asset. At the core of what we present, we are not just companies. Each of these entities are larger parts of what Jamaica presents to the world as its identity. We are, in fact, the face of Jamaica. So what does this mean for managing your workforce? How does this big picture come into play when you are talking about dealing with recovering from the COVID-19 pandemic? How do we address this issue in a manner that focuses on building corporate resilience, a manner that focuses on business recovery, and also protects that valuable asset, that workforce asset that we must hold dear? This is our big picture. So throughout this presentation, we'll be focusing on three broad categories. First, we'll address the context. What is the current climate of the tourism industry? And I thank Mr. Reader for his presentation on this area, which gave a synopsis as to the figures affecting the tourism industry in relation to the pandemic effects. Second, we will dive into the issue. We will identify within the broader context of the COVID-19 tourism industry, what issues plague our ability to manage and restructure our workforce. And third, we'll identify the options, particularly what methods can be put in place for restructuring that workforce in a manner that avoids legal pitfalls and maximizes the output of your workforce entirely. After those three categories are explored, we are hoping that this presentation will give you some guidelines for how you can also treat with government directives, treat with the need, because it really is a financial need, to sometimes cut your labor force in certain areas, and treat with the need to restructure to ensure you have maximized your output. So that is the area of focus. But the starting point, before we dive into the meat of the matter, is understanding who we are. The starting point is understanding that we are service providers. And as service providers, we need to ensure that our human resource, above our other assets, are protected. So let us have a look at the context. Now, this image is a nostalgic one for me. before COVID-19 hit in around 2019, I visited an adventure park in Ocho Rios. Just to keep them anonymous, we will call this adventure park a Magic Hilltop, for example. And this park has bobsled rides, zip lining, and other adventure-based activities. And the platform from which you can do your zipline adventure was very similar to the image you see on the screen. You got up to this platform that was 30, 40, maybe even 50 feet above the ground, and it seemed very precariously attached to a tree trunk. And from this platform, they expected that we would zip line across with utmost confidence. Of course, I ziplined quite easily without any. Okay, so that's not true. The reality of it, in fact, is I did not venture across with as much confidence as I thought I should. And in that moment, what I remember most is not the thrill of the zipline activity. It's not the experience of the adventure. In that moment, what I remember most is the personality of the tour guides, the calmness and the confidence of their tour guides who ushered in a sense of reassurance to all of the visitors before we ventured on the ride. And I think that really emphasizes the point that as members of the tourism industry, our asset and our strength is not in our property, it's not in our income, it's not in our balance sheet, it's not even in the capacity to provide an experience. The value of the tourism industry is in service and in the capacity to provide a human resource that is trained and equipped to also provide that service. So throughout this presentation, you will hear me hark back to that central theme. And that theme is simply this: in an effort to protect your business, in an effort to ensure your business recovers safely, you must first protect your human resource and then protect your profit. So let us look at what this means in dollars and cents. What is the context that has faced the tourism industry recently? And how is that context going to interplay with this need to protect the human resource? So the first thing to look at is the context for the period 2010 to 2019. This is the historical context. The source of this information is statista.com, and it provides a brief look at how many visitors traveled to Jamaica between that period. Now, what we see on this bar graph is a very clear progression from 2010. We are noting 2.8 million estimated visitors, 2.83 in 2010. The light blue and dark blue colors simply represent those who came and left within the same day, or those who came for more than one day. So what this bar graph demonstrates is a progression of the visitor trend upward from 2010 to 2019. And I think Mr. Reader's presentation captured this point. So the trend has been very clear. We've been moving upward to the range of 4.2, 4.3 million per annum of visitors to Jamaica. But what has followed this in the year 2020, we understand, has substantially affected this trend. In the year 2020, and we are currently in July of 2021, we are 16 months away from the first confirmed case of COVID-19 in Jamaica. We faced numerous periods of border closures, including the first closure on March 21, 2020, that led up to June 1st, 2020 and June 15, 2020 for foreigners. We also saw border closures in March of 2021 from visitors from the UK, and further border closures currently in place for countries from Latin America. Those closures expected to extend up to August 10. Now, we know that we've also been facing island-wide curfew. Of course, we are currently under a curfew directive that requires us to be inside by 8 p.m. on weekdays and 3 p.m. on Sundays. We also know that the larger impact of this pandemic is global travel hesitancy. International visitors are very hesitant to travel altogether. And the tourism industry, more than any other sector, has been significantly affected by this. So the consequence of this is that in 2020, the estimate decline in the tourism product to Jamaica was in the ballpark of 87 to 97% lower than the 2019 figures. In 2021, we are still in the region of 55 to 67% lower than the 2019 figures. And this is a global look at the tourism trends. Particularly in Jamaica, the Jamaican Hotel and Tourism Association reported that for the rest of the year and for the rest of perhaps the 12-month window starting now, we are expected to have hotel occupancy capacity in the ballpark of 44%. So we know clearer than any that the trend has been a downward one since the beginning of 2020. And the recovery from that trend is not yet on the horizon. If we turn to some of the very clear indicators from international resources, the reports indicate that global tourism recovery will be linked to vaccine adoption. And this is very important. Mr. Libo has spoke about some of the regimes for implementing the vaccine in the region. However, vaccine adoption was something that was projected by the Ministry of Health in Jamaica, where they estimated that they expect to reach the levels of herd immunity by March of 2022, that level being above 60 or around 70%. What the international reports are currently saying is that Jamaica is at 4.5 to 6% of its complete population fully vaccinated. At this level, we are the second to last country in Jamaica, in the region, in the Caribbean, in relation to the vaccination rate thus far. Quite reasonably, Jamaica is one of the largest countries to have to implement vaccination policies, and we know we have the issues facing the availability of vaccines. But what this means for us is that the tourism industry is not likely to recover until, for example, Jamaica reaches that level of herd immunity, and we are at the moment behind the projections. Finally, the global tourism reports indicate that recovery is not expected until late 2021 at the earliest, or 2023 at the latest. So we are looking at a reality if our country does not pick up the vaccination program and increase the frequency and the rate of vaccination, we are looking at a reality of not recovering in the tourism industry entirely until 2023. And I know this isn't the most optimistic outlook, but it may be a realistic one. So what does this mean for us? What are the issues created and how does it link back to the workforce restructuring theme of this presentation? The immediate issues. First, we appreciate that the tourism business must pivot to survive. The business itself must adapt and must adjust its structure in order to remain afloat. And this is something we had hoped would be done by mid-2021, but it is still a recovering exercise. The international reports are cited, and I quote, "In a crisis, tourism operators are forced to change their operating strategies to survive. This leads to increased levels of uncertainty and require rapid responses to effectively combat the adverse effects of the pandemic. However, the global tourism industry has shown a low level of preparedness in the event of crisis, without sufficient allocated resources to deal with it, and without knowledge of the skills needed to react." So this has resulted in, over the past year and a half, I know my practice and perhaps Mr. Libo's practice has seen the evidence of this. This has resulted in some sharp tactics being adopted in the tourism industry in an effort to cut expenses. So the tourism industry laid off a large proportion of their workforce. The industry adopted large-scale redundancies, and different methods were put in place, which invariably left some major tourism players in some legal trouble. So that's the immediate issue. The immediate issue is that the decline in the industry has led to the businesses taking sharp actions to adapt, and those sharp actions have come at the detriment first of their workforce, who have been cut and severed from the business sharply, and second, the profit of the business, insofar as that workforce has brought labor action against these tourism players as a consequence of those sharp actions. The further immediate issues that we are aware of when these employment restructuring initiatives were put in place, many of us, most of those on this video call would know, they faced some limitations. For example, a layoff in Jamaica is a system by which employees may be sent home without pay unilaterally for a fixed period with the expectation that they may return. But the legislation provides that after 120 days, the employee may treat that layoff as if they were made redundant and may seek redundancy payments from their employer. So there are limitations in relation to layoffs that companies in the tourism industry have had to grapple with. The redundancy exercise, or the exercise of cutting back the employment market altogether, has also created a number of issues, particularly the increased expense of making redundancy payments. The government has provided directives and instructions to employers to have their workforce stay at home, or even to go to the extreme of shuttering the doors of these tourism businesses. And this has been done without any guidance as to how the employment relationship should be treated. And finally, there was no guidance implemented for flexible work arrangements. Those are work arrangements that can be put in place so that both the labor exposure is reduced and the profession of the employee, the employee's position, is preserved. Flexible work arrangements can facilitate that measure. So this takes us also to a future issue. Now this one, the issues described earlier are pretty clear, pretty logical, but the future issue may not be as easy to anticipate. In relation to this, if I may get my slides back on track, here we go. We do have a report from Euromonitor. This is a European statistics agency that did a survey of the global tourism market, particularly in Europe. And what they surveyed was the expected tourism behavior as at July 2020 and the anticipated future behavior leading into 2021 and so on. Now, what this graph demonstrates, and we see the different colors in the horizontal bar graphs, they reflect the expected future behavior of the tourist industry in relation to the short term in light blue, the mid-term in orange, the permanent long term in purple, and so on. So what this bar graph reflected, as we all expect, is that in the mid-term, the large subset of the tourist industry decided to take more holidays closer to home. They decided to reduce international travel, and they decided to reduce overall spending. These go without saying. What was important and what is noteworthy about this statistic is that final row where it reads greater attention paid to how companies treat people. This category resulted in the largest finding for permanent change. I'll say that again. As it relates to the survey of the tourist market, the largest section of permanent change affected by the pandemic was in the category of greater attention paid to how companies treat people. So what does that mean for us? As members of the tourism industry, our success after the pandemic is largely connected to how the public perceives our treatment of people. We all appreciated the midterm and the short-term consequences. We appreciated that we would see a reduction in our business and in our traffic. But we didn't anticipate that because of a global pandemic, the market that we are catering to would be more concerned with our treatment of our audience, our visitors and also the treatment of our employees. And it is for this reason that there is a direct connection between your immediate employment strategies and your long-term profitability. And that's what I call the future issue. So the approach adopted following the same Euromonitor report, the approach adopted in the European Union were threefold. Of course, digitization and sustainability is at the fore. And at the bottom, we see a mention to a greater opportunity to rewire and take forward thinking approaches to social and environmentally sustainable practices. But it is this category in the middle that I want us to focus on, where it mentions that travel brands and destinations that act with purpose, striking the right balance between people, planet, and profit, will be best placed to succeed. I believe, and what it is I want to emphasize here, is that the strategies implemented now aimed at our business recovery for the rest of 2021 and into 2022 should focus on how we can strike the right balance between our people and our profit to make sure we are best placed to succeed. So here are the options. We've identified the context of the global tourism market. We've identified both the current and future issues. But what options are available to us? And I think it falls into two broad categories. The first category being voluntary, the second category not so much. The options are for business-driven restructuring or for government-driven restructuring. Business-driven restructuring is a broad term for any measures put in place by the tourism player to rearrange their workforce internally. Government-driven restructuring are measures directed by the government, whether it be through quarantine orders, work from home directives, isolation orders, or even the closure of the tourism sector. These government-driven restructuring force the tourism players to make certain decisions that affect their workforce. So how can these different options be implemented? And how can they be done considering those two aims, protecting the business's profit and protecting the business's people? Starting first with business-driven restructuring. The categories, some of which are very well known, include redeployment, laying off workers temporarily, reducing the work hours and salaries of employees, utilizing sector mobility, this one may be new to many of us, and reducing the workforce permanently. There are ways to implement and to adopt each of these restructuring steps in a manner that keeps you on the safe side of the law and in a manner that also appreciates and keeps cognizant of your workforce. So starting first with redeployment. Redeployment, simply put, is the movement of an employee into a different role or department within the business that you are employing. An illustration of this could be that your hotel has been directed by the government of Jamaica to close its doors for a fixed period. During that time, the hotel may find that it is unable to welcome visitors or to operate in its usual capacity. A key element of any hotel for the welcoming of visitors is that they have a front desk management team that is engaged and trained in relation to handling that type of in-person interaction. Now, it's quite expected that this front desk team will not have a role to serve in the event that the business has to close its doors. That goes without saying. But during this period, if, for example, the hotel also decided to do refurbishing while the government closure directive was in place, an option may exist for the same front desk management team to take up a role in that refurbishment exercise. And this is, one of the rather extreme examples. But for example, the members of the front desk team can fill specific roles, including taking inventory or performing quality control of the refurbishment exercise. They can supervise workers. They can monitor work shifts of employees coming in and out. And if that type of redeployment was adopted, what you accomplish is potentially a reduction in your contractor costs for refurbishment on one hand, as well as a maintenance of your employment output from your front desk employees. So in that manner, through redeployment, you've been successfully able to reduce your expenses and protect your workforce by looking for the opportunities to redeploy, as opposed to, strictly speaking, laying off the worker without pay or even cutting your workforce to account for this cutback measure. So in this way, redeployment is very useful. Now, here are a couple of the rules that govern it. Redeployment requires a change of contractual terms. As you may have heard from legal advisors throughout the course of last year, you cannot change contractual terms unilaterally. It must be done with consultation and with the consent of the employee. So strictly speaking, if you wished to redirect an employee to another part of the business, a different role, or into a different department, you cannot do it without the employee's consent. And what we recommend is that any modification of their employment role be documented in writing and the employee sign confirming their consent. This last bullet point is important because there is also a consequence for the consideration of redundancy. In the event that the employee does not agree to be redeployed to a different area, and you are constrained to then lay off the employee, what you may appreciate based on my description of the layoff limitation earlier in the presentation is that if an employee is laid off for more than 120 days, they may treat that layoff as if they've been made redundant, and that may come at certain expenses to you. But the legislation provides that if the employee made an offer of suitable employment, and that usually means the compensation is not reduced, the location of employment has not changed, the broad category of the responsibilities are similar. If the employee made an offer of suitable employment and the employee has refused that offer unreasonably, that employee loses their redundancy benefits. So this is why redeployment is very important, and it can save you quite a penny if you seek to adopt it before considering laying off or before considering redundancy. So let's have a deeper look at the temporary layoff of workers. I know some members in our audience are from overseas, and the word layoff typically, and speaking specifically about the United States market, is a word that refers to the broad cutback of your workforce. Now, layoff in Jamaica is not treated in the same way. A layoff in Jamaica is the temporary cutting of your workforce pursuant to the terms of an employment contract or as a result of a change in circumstances of employment so that the employee receives no pay for that period. So a temporary layoff contemplates that after a fixed period, the employer will be making a decision to bring that worker back. And this differs from the way in which the words are treated in the United States. So strictly speaking, the circumstances that may have changed that lead to a layoff of an employee are not defined in the legislation. Those circumstances are very broadly considered. It is my opinion that, of course, the effects of the pandemic and the need to shut or reduce the workforce at your business as a result would meet the requirements of those circumstances. It's also my opinion that government directives or the closure of the entire tourism industry would also satisfy the test of being a circumstance in which employees may be laid off. How can this be done? First, layoffs can be done unilaterally, but it cannot be done in disciplinary situations, and it cannot be done punitively. What that means is, simply put, if an employee has done something that you believe is misconduct, you cannot send that employee home without pay and claim that that employee has been laid off. That would be considered a breach of the employee's employment rights. On the other hand, it can be done unilaterally, meaning without consent of the employee, but it must be for one of these two grounds set out in under the first bullet. It must be done unilaterally because it is permitted by the employment contract. There is a term in the contract that allows for laying off, or the circumstances of the employment have changed so that the employee receives no pay, and not in instances of disciplinary situations and not punitively. We've already discussed on a couple instances how layoffs may lead to redundancies. So the safest mechanism for your business, if you are constrained to take this course, if, for example, redeployment has not been successful and you do need to cut the workforce simply to protect the bottom line, or simply because there is no need for that worker to work for a specific period, we do know that it could lead to a redundancy if that layoff period exceeds 120 days. So this is a brief synopsis of how the layoff rules operate. And quite candidly, it can be adopted unilaterally, but it has its limitations, especially in relation to its timeline. The third option for restructuring internally, the business-driven restructuring exercise, is to reduce the work hours and salaries of your workforce. As it goes without saying, of course, that this also requires a change to the contractual terms, so it also must follow consultation and the consent of the employee. You cannot change any contractual term without obtaining that consent, and as we recommended earlier, it should be acquired in writing. Now, this is an interesting point that has to be handled very delicately. It would be considered unfair to an employee if an employer were to threaten redundancy in a measure to have the employee take reduced work hours and reduced salary. Threatening redundancy is not considered a fair labor practice in Jamaica. However, employers can, in a very open, a very direct, and a very honest way, explain the needs of the business. An employer can consult with the employee and outline that at the moment, we are faced with a dilemma that requires us to cut our workforce. Now, what we recommend when attempting measures of this nature is that the employer be prepared to go down a certain path, be prepared to lay off or to make redundant the employee and to pay the necessary sums to match that prepared choice. And once that decision is made, the option may be presented to the employee to allow them to re-engage with the employer on reduced work hours or for a reduced salary. Now, what is clear in the legislation on this point is that if the employer does in fact lay off its employment base and then invite them to work for reduced hours and for a reduced salary amount in a mechanism to adopt this strategy, that is still considered part of the layoff period. Yeah, so we cannot overlook that point. The layoff period of 120 days, after which the employee is entitled to treat that layoff as redundancy, will still run during a period of reduced work hours and reduced salary. So it can be pitched as an alternative to redundancy. It can follow the laying off of an employee, but it does not erase the need to consider that layoff limitation. Sector mobility. Now, this category is a category that I think is rather new to a number of the players in the industry. Sector mobility is a term that refers to the capacity of a company to have its employees reassigned to different locations or even to different businesses. So it is different from the concept of redeployment, which is the reassignment of your employees to a different role within the same business. Sector mobility instead considers what are the strengths of the tourism industry and therefore what are the attributes of your workforce and how can those attributes serve other businesses and other companies in a manner that both preserves jobs and reduces or eliminates the labor exposure that the employer may face. So if I put it in very simple terms, sector mobility is a mechanism that allows a hotelier or a restaurateur to simply reassign their employees to a neighboring business for a fixed period of time because there is a decreased demand in the tourism industry, presumably as a result of the effects of the pandemic, and an increased demand at the neighboring business. So let's look at some of how that may work. First, the first point to pay attention to when considering attributes of sector mobility are what are the strengths of both the tourism industry worker and how transferable are those strengths. Those are called the sector transferable skills. So the tourism sector in our large center circle covers each of these sector transferable skills. It trains its employees on language skills, cleaning skills, administrative skills, management and leadership skills, in some instances, medical skills and teaching skills. At the core of these different categories, there are these sector transferable assets of emotional labor, communication, empathy, big picture thinking, and the ability in finding a common ground. We know that in that instance, the hospitality sector has the capacity to have its employees work in retail, in aged care, in education, and in other areas of the tourism sector. So what this means is that your workforce not only has the skill set, but it is also specifically trained for capacity to handle the business of other players in separate industries. We know, for example, as soon as the pandemic hit, the tourism industry came to a sudden halt. After a few months, the industry returned to some form of functionality, but again, it was a reduced kind. At this time, we also saw an increased demand in the healthcare sector, also an increased demand in relation to supermarkets, and an increased demand for delivery services, and so on. There was also, of course, an increased demand in telecommuting or in the BPO sector. So this sector mobility idea, it's a rather novel idea, and it was hypothesized just recently by some international scholars, is a very useful idea in our sector if you are able to take the time to implement some very specific steps. So those steps looked at briefly to give the freedom for the employee that is envisaged in this image. It requires training and skill set assessments to identify where each of your employees fit on the sector transferable skills diagram. It also requires the consent and the contractual amendment of that employment arrangement between the company and the employee. Of course, you cannot second, so to speak, an employee to another business without it being part of the contractual terms. It relies on corporate partnerships. The tourism players must, for example, have a connection with other businesses and some form of corporate partnership that allows them to send a portion of their workforce to meet a specific need. And finally, it is at the cutting edge of the human resource innovation spectrum, insofar as it allows the company to show it's exercising a strong tool for compliance with labor laws. So sector mobility, I think, is really at the heart, alongside redeployment. It's at the heart of the initiatives that should be adopted if you are focused on both people and profit in an effort to build corporate resilience. So the final area in relation to the business-driven restructuring, of course, is reducing the workforce permanently. Broadly speaking, this falls in the category of redundancy once the ingredients are met. This one we all have a lot of exposure with over the course of the last year, so we've provided here a very brief synopsis as to the guides that should be adopted in the case of redundancy. Before I dive into the guides, let me explain for those who may not know. A redundancy, simply put, is the reduction of your workforce due to a reduction in the business or due to a diminution in the service being provided that no longer makes all of your workers necessary. If that reduction takes place, and if the employee meets the specific criteria, that is, they've been engaged for at least 2 years of employment at the company, then that employee may be treated as dismissed by reason of redundancy, and they may be entitled to certain redundancy payments. So that's the first step. You must assess to identify whether a redundancy situation exists. It certainly can exist in instances of workforce restructuring pursuant to government directives, and it can also exist if the business has to cut back as a result of the pandemic. Point 2, adopt a fair and objective selection criteria. Don't make the employee redundant because you don't like him or her. Consider an objective selection criteria, for example, last in, first out. Item 3, warn the employees about the possibility in writing. This first warning letter should also invite them to a consultation meeting and advise them that the company is considering restructuring its workforce because of this issue. Item 4, consult with the affected employee individually. This consultation must be meaningful. The employer must consider the suggestions of the employee to avoid redundancy, and it must be done in a manner that shows respect to the employee's position at the entity. Item 5, you are required, and many people do not know, you are required to notify the Ministry of Labour of potential cases of redundancy. And item 6, assess and pay redundancy payments to the employees according to the legislative formula. So this takes us to the government-driven restructuring, and this is the category in which the government has directed either the work from home of your employment force, the quarantine of your workforce, or the closure of the tourism sector altogether. Now, work from home and quarantine directives can be dealt with together. They are treated in a similar manner. And in essence, the issue here is that there is very limited direction on how the employer should handle the quarantine directive or the work from home directives. There is no direction as to whether the employee can be made to take sick leave, whether the employee can be made to take vacation leave, or whether the employer can treat this period as a layoff period and not pay the employee at all. So in relation to both sick leave and vacation leave, we know that strictly speaking, the employees who are sent home or quarantined may not fit within the leave categories. That's so because employees may be sent home even if they are not sick. If someone else is sick and they are a direct contact, the government may require them to work from home. If they are not sick, but the government wishes to lock down a particular business to prevent a workplace cluster from spreading, that is also a category that does not fit within the sick leave criteria. Now, while this is the case, while employees do not typically fit within these categories, there is a ministerial directive that came out in 2020, in March of 2020, and the Minister of Labour did it by way of video, where employers were encouraged, so to speak, to apply leave entitlements to employees who are being required to work from home. This recommendation came in very loose terms. It did not authorize the employer to mandate that sick leave or vacation leave be accepted, but it encouraged the employer to do so. So how can these two things coincide, especially when the employees do not fit the leave categories? We recommend that certain procedural steps be taken before employees are required to use their leave for these purposes. Particularly, COVID-19 response policy should be implemented if the employer wishes that the employee utilize sick leave or vacation leave to cover these particular areas. And that policy must, as we've said earlier, be implemented with the consent of the employees. We recommend that it is done before the directives are put in place from the government, because when the directive is in place and the employer has to implement something that forces the employees to stay at home, you are likely to see a lot of pushback from the employees when seeking their consent. So the policy should be put in place before the directive is given, and it should be signed by the employee. And finally, if an employee is sent home for an extended period without receiving salary, layoff periods may also be applicable. That would be considered akin to a layoff of that employee, and the same rule regarding 120 days will apply. The final area, and this is my second to last slide, relates to the closure of the tourism sector. Should the government direct that the entire industry be closed, the same rules apply as those from work from home directives. Strictly speaking, it does not, of course, fit any of the leave categories, but if a policy is put in place that permits the employer to use those categories with the consent of the employee, it can be adopted. Additionally, in the same way as outlined earlier, layoff periods may be applied with specific provisos, and that is that redundancy may be exercised, or it may be taken up by the employee if they are laid off in excess of 120 days. And employees who claim redundancy are likely to face challenges. And that's, of course, because strictly speaking, we know redundancy requires dismissal for the reasons outlined earlier, and the closure of the tourism sector does not quite amount to the dismissal of employees. But again, if these employees are laid off during the closure period for 120 days or more, an employee can successfully claim that redundancy. So here are my key takeaways. And I want us to pay attention to what you heard at the beginning of the presentation and what you're hearing now. What are the core aspects of the service industry? They are, in fact, built on the back of our service personnel. We aren't companies, we are service providers. And as a service provider, our workforce is at the core of our business model. We must strike the right balance between people, planet, and profit if we are to be best poised to be successful at the end of this pandemic. And where possible, use redeployment and social mobility to avoid instances of layoff and to avoid instances of redundancies, because these restructuring mechanisms protect the person while also protecting the bottom line. And where necessary, if you have no other choice, follow the steps for layoffs, reductions, and redundancies very carefully and make sure nothing is left out. Ladies and gentlemen, thank you.
Thank you. Thank you so much, Jonathan, for comprehensive information again. Thank you to all the presenters. For many of you who are not aware of the Jamaica Hotel and Tourist Association's role, and by extension, the tourism sector's role in the recovery from the downward trend in occupancies and the resulting reduction in the contribution to GDP, which, by the way, is estimated at approximately 25% of GDP. You have heard it from our president, the president of the Jamaica Hotel and Tourist Association, about the resilience corridor, the model of which was recognized firstly in Jamaica by the WHO. The ambassador program, which was implemented by the JHTA, which spoke to mass distribution through partnerships between the quasi-government organizations and the private sector in distributing mass to several areas. The cost containment measures while implementing mandatory and necessary COVID protocols, while creating a balance between lives and livelihood, as the Prime Minister had said. And as Jason called it, the treatment of the balancing between people, treatment of people and profit. So we want to thank also the legal team from DunnCox for the guidance in relation to the treatment of employees in redundancy exercises and redeployment, and how to treat with contracts and how to exercise vaccination procedures as part of employment process. And during and post-COVID, And of note, and as was stated at the outset by Emil, the recommendations and advice given by both himself and Jason are within the context of what we all know now, as well as the legislation that now exists, as well as the ones that are in train. So we move now to a question and answer section. We should just advise you that if you want to ask a question, you may use the hand raise feature, and the host will recognize you and open your mic, allow you to speak. Otherwise, you may use the chat feature and ask a question there, and I will pose it to the relevant presenter for them to respond. I have a question first from Lawson Douglas, who says first, the American use of the term furlough for layoff. The Americans use the term furlough for layoff. And his question is, what happens if the employee does not elect to be made redundant after the 120 days?
Thank you, Chris. Yes, strictly speaking, the redundancy after 120 days of layoff is at the election of the employee. So should they not elect to be made redundant after 120 days, the layoff period simply continues until the employer returns that employee to work. It is upon the service of notice by the employee that the redundancy becomes effective. Now, that may sound comforting to employers, but we must caution that upon the expiration of that 120-day period, the employee has the right to serve the notice. So the employer permitting that period to elapse runs the risk that they will receive a notice at some point.
Okay, thank you. I hope that answers your question, Lawson. I will just ask one of my own, since I don't see any raised hands at this time. You had spoken, Jason, about redeployment, and in your description, it sounds to me that it still seems to leave a bit of gray area with respect to the interpretation by the employer as to what might be a suitable area of work for the redeployment. Would you say that that might want to invite mediation, or are we not there yet?
Thank you, Chris. So redeployment, again, is a measure that can only be put in place with the consent of the employee. On that basis, the suitability of the alternate position, the alternate role that you wish to redeploy to, is only relevant insofar as the employee may not agree to something that they believe to be perhaps too far from their original position or somehow beneath what they were employed to do. So if the employee agrees to something that is entirely different from their original terms of employment, it still constitutes redeployment because by consent, the contractual terms may be modified. If the new option is too far-fetched or too estranged from the original position, it of course affects the likelihood of having that employee agree.
Okay, thank you. Thank you for that clarification, Jonathan. I have a question from Anonymous. Due to COVID, we closed our resort from April last year and laid off the employees. After 120 days, took back the staff to work for 50% of the time they would normally work with half pay. Is that illegal? What can be done now? Did you get that question?
We got it.
I'm not hearing.
Emil and I were conferring for a minute.
Oh, okay.
Yes. So the question, strictly speaking, was it legal?
Was it illegal? Yes.
Right. Let me just be clear that we shouldn't look at it in such black and white terms because the legislation provides that there are options available if an employee is laid off for 120 days and that layoff continues. So before I get into the heart of your question, Chris, it is legal to lay off for a period that extends past 120 days, but the employee at that point may treat themselves as terminated by way of redundancy, and the employer will be required to make redundancy payments. So it's lawful, but there are consequences. Now, dealing specific to this question, the closure of a business and the layoff of their workforce for 120 days, and then the re-engagement at 50% compensation would only be a safe labor practice if it was done with the consent of the employee and the employee agreed to the modification after that 120-day period. If the employee did not agree to the modification and this 50% salary pay was implemented unilaterally by the company, the consequence is that the employee may treat this as constructive termination as a result of the unilateral change of their contractual terms, or two, the layoff period may be considered to have continued and the employee would have accrued the right to tender a notice treating their situation as terminated by way of redundancy. I'm not certain if Emil has anything to add on this one.
The only thing I'd add to that, Jonathan, is that the employer may be liable for the shortfall in pay if there is no agreement. So there is a difference between paying somebody a sum lower than what they are contractually entitled to and having an agreed change to the terms and conditions whereby, for example, you agree to work fewer days at a lower rate, right? If it is that you're bringing them back to work their usual working hours and days, but for less money and it's unilateral, then you may actually owe them that shortfall at the end of whatever period is applicable or upon a redundancy. And also for clarity, the redundancy sum would be calculated based on the full salary sum,
Right,
and not the 50%.
Okay, I think you may have addressed this, but he had asked as well, how soon after the employee request to be made redundant, does the employer have to pay the redundancy?
Yes, strictly speaking, the employee's request to be made redundant after the 120-day period must be given 14 to 60 days in advance of the date of redundancy. What that means is that employee's notice must say to the employer, we have been kept out of our salaries for more than 120 days. We therefore now give you at least 14 or at most 60 days notice that our termination date shall be X. Upon receiving that notice, the deadline set out in that letter could be treated as a deadline for making that redundancy payment because it is the date of severance of the employment relationship. In a practical sense, a number of our clients have treated the effective date as a salary date. So whenever they are doing their regular payroll, the termination payments are included in that payroll. But I think the safer practice is to use the final date of employment as the date on which the redundancy payments are made.
Thank you, Jonathan.
I'll just add to that, Chris, that you can again agree with the employee to a payment plan. So if you don't have the cash to make a single lump sum payment, you can always have an agreement with the employee that you'll pay it insurances over time and that type of thing. So communication is always key.
Thank you, Emil. Steer asks, wages were cut without written acceptance from staff involved and asked to work same for 40-hour work week. Do we have any recourse?
That's an interesting issue. Without the acceptance of staff, of course, is the largest hurdle. I do recommend that this attendee get some legal advice on their particular scenario. But off the cuff, I would recommend that the employer reinstate their workforce immediately before they receive any notices, treating their situation as terminated by reason of redundancy, and hope that that reinstatement now before the notice has the effect of avoiding the occurrence of paying redundancy payments down the road. Now, this would not avoid the obligation to perhaps back pay the shortened salary for the same amount of time worked, that being the 40-hour work week that was maintained during the period. But off the cuff, that would be my recommendation. But again, the scenario should be looked at carefully, scrutinized by a legal advisor of their choice, and they should gain some advice, some cogent legal advice on that subject matter.
Thank you, Jonathan. If an employee gets pregnant during the layoff, what is to be paid as leave for her?
Chris, I'm sorry, I was distracted. Say that again for me, please.
If an employee gets pregnant during the layoff, what is to be paid as leave for her?
Very interesting.
It would not remove the obligation for maternity leave because it's two separate, paid maternity leave, because it's two separate pieces of legislation. So you're right, under the Maternity Leave Act, once the employment subsists. So remember, layoff is a suspension of employment whereby the worker has no obligation to work and the employer has no obligation to pay. But the maternity leave legislation speaks to being entitled to paid maternity leave once you meet the qualification of having worked for a year continuously. So I would say you'd still need to pay the maternity leave.
Yeah. Strictly speaking, Chris, I know that maternity leave is usually accepted at the end of the term, 1 month before delivery and 2 months after, or something of that nature. So if they get pregnant during the layoff period, the layoff period being 120 days, the two are not likely to interact. But in the event that the layoff period crosses into when the maternity leave is being taken, Emil's comments definitely apply.
Okay, thank you, Emil and Jonathan. I have another anonymous asking, is vacation leave still being calculated during a layoff period?
I would say no, actually. Again, the Holidays with Pay Order 1973 says you accrue 1 day's leave for every 22 days worked. So I'll be frank, it is not addressed in our legislation, but my view is that during the layoff period, you're not working, so you wouldn't necessarily be accruing leave, because the premise of vacation leave is that you're entitled to some paid holiday because of all the days you've been working. I'm not sure if you need a vacation from your layoff, So,
okay.
My personal view is that it would not accrue during the layoff period.
Okay, I think this might be a follow-up. If the employer lays off the employee but still has the employee coming to work, is that considered layoff? And does vacation still accrue?
So just to be clear, the employee is coming to work but not receiving pay?
I'm reading it as I see it here in the chat. I'm not sure of the details of it, but it says if the employer lays off the employee but still has the employee coming to work, is that considered layoff, and does vacation still accrue?
And let's unpack that a bit. Well, what I've seen is that it may be that you're called in from time to time during layoff. That does not end the 120 days or suspend the 120-day calculation if you're called in periodically to do what I call one-off things. But certainly, arguably, every time you're called into work, that would then count towards your 22 days worked. That also needs to be considered in the context of what your contractual arrangement is. So when I speak about accruing 1 day for 22 days, that's the legislative accrual. If you have a contract that says you're entitled to 3 weeks vacation leave every year, and that's what your contract says, the layoff would not affect those contractual benefits. So if your contract, if your policy doesn't speak to a principle or a policy of accrual of leave similar to what is in the statute, then the employee is still entitled to their contractual benefits. So that's why, you know, there's not a single, what I call open and shut statement, because each employment environment might be different and different factors may apply. But if you operate under what I call the statutory regime, then it is when you work that you accrue.
Okay. Notwithstanding that we're here getting some free legal advice on some matters, we're a bit over the time that we have allotted for it. We're going to take a few more questions up to 12. That's just 7 minutes more. We have a question here from Antoinette Chen. What happens if during your layoff of the employees, what happens if during your layoff, the employee's contract has expired? How is this treated?
You would write to the employee and indicate that your contract having expired during the layoff period, presumably it will not be renewed, but you shouldn't just leave it silent. And so the employee has no expectation of a return to work or a new contract. So the expiration of the contract ends the layoff period automatically, because layoff is a suspension of employment during the employment period, right? So once that employment period ends, then it's no longer suspended, it's ended. But you should document again and make clear to the employee that it's not that you're laid off for your last 2 weeks of your fixed term, so you're going to come back and get back another 2 weeks, right? It should be that the employment is suspended up to when it expires, and then that is it.
All right, I have what appear to be 2 follow-up questions. One is asking from Trial Club, are you referring to a fixed term contract in regards to 3 weeks vacation agreement in the contract?
It can be any type of contract. As we know, the minimum vacation pay is 10 working days or 2 weeks each year, and subject to your seniority and that type of thing. It's a scale. But if you are on a fixed term or if you are permanent, you can agree to any leave provision. You can have 6 weeks leave per year if that is what you generously as an employer wish to provide. But you just can't fall below the 2-week minimum for new employment, whether you're on fixed term, and that being fixed term of at least 1 year, right? Or permanent employment.
All right. This one is also appearing to be a follow-up from the question of the person who was talking about being called back to work. They're saying not called in periodically, but returning to work, but at work 3 or 5 days a week consistently. I think this was speaking to the matter of them being laid off and called back to work.
Let me put it this way. I don't think this forum, we're not really going to, it's not.
I know this appears to be a specific case that the person wants some advice on, and we may want to refer them to the Industrial Wage Tribunal or Labor Board.
IDTN, Chris. We're not sending them to IDTN.
It's just my comment, Chris, that once we get into specifics, proper legal advice should be provided. So okay. Someone would provide all of these parameters in another forum, and a legal advisor of their choice can provide advice on it. You know, we
Okay. All right. All right. Thank you, Johnson. We'll take this as the last question. What if the employer who is laid off refuses to return to work when he or she is recalled prior to the passage of 120 days?
That now can be dealt with as a disciplinary matter, as an act of insubordination, or job abandonment. So that you'd still have to follow due process before you can end the contract. But a refusal to return to work, can form a basis on which an employer can validly terminate a contract of employment without any obligation to pay redundancy.
Okay. All right. All right. I think we'll call it the last. There's still some questions rolling in, but as we said, we are way over the allotted time. We want to really thank the legal team. We've really gotten some great guidance with respect to how to proceed. And it seems there are several people asking whether the recording will be made available so that they can review the information. I will move that to your team, Emil, to advise how it is that that we may be able to share the information.
Yes, so the recording, it is our intention to make it available, and it should be shared on our video sharing platforms. I believe the firm has a YouTube page where the recording may be uploaded in the next couple of days. All right.
Okay, so thank you all. Thank you for attending and for sharing and for the questions and comments. And as you heard from Jonathan and Emil, it will be available and for you to review and be further guided.
Thank you, Chris. I appreciate it.
Chris, it has been our pleasure, and we appreciate being able to share with the audience as well on these issues that continue to plague us in our mission towards business recovery. Thank you again to you and to all of our attendees.